Well, welcome. I'm Victoria Cobb, president of the Family Foundation. We're thrilled that you're here. Some of you have been a part of our entire VIP chat series we had been doing during what I like to call the lockdown, but during our shelter in place period that was rather lengthy here in Virginia. And we got to hear some awesome speakers during that period of time, learn some interesting issues a little bit better than we knew them before. And we had a great time doing that. And some of you are probably brand new tonight, probably heard about this. It's a hot button topic for you, or it's a new Supreme Court decision, and you want to kind of hear where we're going to go from here. And so for some of you, welcome. I'm thrilled that you're here for the first time. Hopefully you'll find it beneficial. We are in the evening hour this time. Our rest of our series we did sort of during lunchtime while people were in theory, probably working from home. I know folks are kind of mixed right now, but we thought, well, we'll do it in the evening and see if that helps with folks who are back to work now, more in their offices and so forth. So here we are. We're thrilled to have you. It's been a big week. What to say? I'm not going to say a lot because we have awesome people to say a lot about this. But we've been waiting for Supreme Court decisions. There's actually a lot of Supreme Court decisions that are very impactful for the work that the Family Foundation is passionate about. We're really waiting this June season. We sort of look at June and we know the Supreme Court's going to issue a ton of decisions. And we really had about 6 different decisions that were really critical to our work. So we still have a lot in front of us. But this was probably, I would say, the biggest decision we expected to come back this season. And we were not expecting this outcome. What we're going to do is unpack that for you tonight, and we're going to do it with some real experts. Now, I tell people, typically the maximum lawyer you want to have is 1, because the joke goes, if you have 2 lawyers in a room, you get 3 opinions. I can make these jokes because my husband's a lawyer, so I'm used to making these jokes. But actually, we have 2 awesome attorneys here. And they're going to kind of help us unpack that. So tonight with us, first of all, we have Jim Davids. Jim has been an attorney for 40 years. And a lot of folks might know him in Virginia because he was actually at Regent University teaching law in addition to, practicing law. So a lot of folks know him from that environment. He is on our board of directors, so we benefit every day from his legal opinion and just his sound advice. But he's also got a PhD. That's a little unusual for attorneys in this issue, in an issue that is relevant to this topic tonight. He actually did his PhD on higher ed and the challenges that I don't even know if it's higher ed, education in general, I should say, and the challenges that they're going to face in the future. And one of them was sexual orientation, gender identity. And so here we are now watching that unfold. So we've got Jim Davids, and the other piece I should say, which I'll talk a tiny bit more about at the end, is Jim is also the lead attorney for our new legal center. I'll talk about that at the end, but Founding Freedoms Law Center, we're super excited, and he's going to be spearheading that. We'll talk about that just as we close out tonight. And then the other attorney we have with us is Matt Sharp. Matt is with Alliance Defending Freedom. We have been just thrilled with being able to be a partner with Alliance Defending Freedom. They are just tremendous in this arena. They have litigated a lot of cases around these issues of sexual orientation, gender identity. And specifically, we got to know Matt best when we were in Virginia battling the case about gender identity, dealing with, if you remember, Gigi out in Gloucester. So we had this situation where a school board wanted to say, here's our policy, bathrooms belong to biological boys and girls' bathrooms belong to biological girls, and we're not going to be confused and put our students at risk for people who would take advantage of a policy that was nebulous on the issue of sex. And so Matt has been critical to just an intricate part of that case as it went all the way to the Supreme Court and back down, and around and around it goes. And so we were just appreciative of his help coming alongside specifically us in Virginia as we sought to uphold really what is actual sex. And now here we have it. That question came before the court and they answered. So if Matt and Jim want to join us here and come on screen, we will start kind of, we've got, just to outline the format tonight, we've got a series of questions that I'm going to ask. And in addition to the questions I'm going to ask, you can put your questions in the chat box to the right. So you should have a section that has questions over to the right. My goal is to be able to get to some of those if we can. Hopefully, I know we're going to have some meaty discussion leading up to that. Maybe we will answer things that are on your mind. But make sure that you know where to put your questions, so at least we can see them. So I'm going to kick this off so that we get lots of discussion before. Our goal is to try to wrap things up around 8 o'clock, but if we're still in meaty conversation, we'll go a little bit longer. But so I'm going to just kind of launch right into it. I think people are wondering, you know, they heard, I think people in the news like generally gave, here's the outcome of these cases. But I think people are kind of curious, who are the parties in these cases? What were they disputing? Kind of what were the legal matters at hand? So lay out the fact set for us, and they're complicated, and I recognize we can't get into every detail about that. But maybe Jim, if you could lay out a couple of the cases, and then maybe Matt, if you could talk about specifically the one that Alliance Defending Freedom was kind of point on, that would be awesome for our folks to kind of get the framework first.
There were three different parties that were defendants or petitioners in this particular case. One was Mr. Bostock, who's the principal guy, the first guy. It's in the opinion. Then secondly was a Mr. Zarda from the New York area. And then the third one was the Harris Funeral Homes. They were represented by Alliance Defending Freedom. So I will let Matt talk about that. Well, with respect to Mr. Bostock, Mr. Bostock was a child welfare advocate over in Clayton County, Georgia. And under his leadership, the county won various national awards for his work. And after a decade with the county, Mr. Bostock began participating in a gay recreational softball league. Not long after that, some influential members of the community made some disparaging comments about Mr. Bostock, and particularly about his sexual orientation and also participation in that gay baseball league. And soon afterward, he was fired for his conduct, which was deemed unbecoming of a county employee. He brought suit not long thereafter down in the 11th Circuit Court of Appeals, which of course includes Florida and Georgia. And his case went up from there. He actually lost in the Court of Appeal, so you had that. Then the second one was Mr. Zarda. Mr. Zarda worked as a skydiving instructor at a place in New York State. After several seasons with the company, Mr. Zarda was mentioned that he was gay, and days after that, he was fired. In Mr. Zarda's case, he won at the Court of Appeals level, so there was a distinct conflict between the Second Circuit, which of course includes New York, and the 11th Circuit, which is Georgia. So you had two appellate courts going in different directions, and that's one of the reasons why the Supreme Court took this case. And the other one was R.J. Harris. Over to you, Matt.
Yeah. So Tom and Nancy Ross are a great Christian couple, and for many years their family has owned Harris Funeral Home. They serve grieving families in their communities, and several years ago they had hired a funeral director whose name was Anthony Stevens. And funeral directors, they interact directly with the families on many occasions. I'm sure many of you have had those experiences, and when you've lost a loved one, and you know how important that relationship is, and the need to really be sensitive. Well, as part of the requirements for their funeral directors, men needed to be dressed in a nice suit, conservative suit. Women needed to be dressed in, similarly dress or other sort of appropriate attire for a female. And one day, Anthony Stevens, in a letter to the Tom and Nancy, said, "I'm going to start identifying as a female and go by the name Amy Stevens, and I'd like to start wearing a dress while I do my job." And the Ross family explained, "Look, what you do on your own time is your business. But when you're here, we need you to follow our dress code." And those dress codes are permissible. Title VII, the law that's issue here that we'll be discussing more, specifically allows employers to have sex-specific dress codes. So men dress one way, women dress another way. And it ultimately boiled down to Stevens saying, I don't want to wear it. And that ultimately led to them parting ways. And then Stevens turns around and sues Harris Funeral Home, saying, you discriminated against me based on my gender identity. And I think that's a form of sex discrimination under Title VII. And unfortunately, they lost those cases up to the Supreme Court, which led them, along with the Zarda and Bostic, all of these cases making its way to the Supreme Court, which then combined them all together for one day of argument and sort of a mega case dealing with this question of what does sex under Title VII mean?
So we have all these cases, they come together, they have one big hearing, and we find out we have a 6-3 majority conclusion. I think it was a little shocking to folks, not just that we didn't win this on our issues, but we also had such a strong number. We were expecting maybe a 5-4 split one way or the other. Matt, can you give us a little explanation about what the conclusion was and the rationale, and maybe some comments on the dissenting opinion, and then Jim can follow up with anything else?
Yeah, so as I mentioned, the case was arguing about, does Title VII, which was one of the laws passed in 1964 as part of the Civil Rights Act, this bans employers from discriminating based on race, religion, and sex. And the other side was arguing, we think sex should include sexual orientation and gender identity. So if you take an adverse action against an employee, you refuse to hire them or terminate them or something because of their sexual orientation or gender identity, you're violating Title IX or Title VII, excuse me. And the other side, our argument, and the others, was when Title VII was enacted, it was about remedying unequal opportunities for women. We wanted women to not be denied a promotion or not be denied a job that a similarly qualified man would have been given. And so a lot of the case was boiling down to, are we going to maintain the long-standing understanding of Title VII, or are we going to redefine it? And in the opinion by the majority that was written by Justice Gorsuch, he did what one of the dissents calls was legislating from the bench. He and the majority redefined Title VII so that rather than it being limited to discrimination based on sex, it now encompasses sexual orientation and gender identity. This was not what the drafters intended. This was not what was originally thought of when this law was enacted. And how Justice Gorsuch did was he basically based it on a hypothetical. He said, imagine you have two employees and they show up at a dinner party with their employer, and they bring their wife. And one of them is a male bringing his wife, and the other one is a female bringing her wife. If you treated them differently, you fired the female because she brought her wife because she was a lesbian, then you have discriminated against them based on their sex, because you're treating the female that's married to a woman differently than the male that's married to a woman. And he brought up some other scenarios, but they all boiled down to that, of him saying, you can't treat someone differently based on sexual orientation or gender identity without also taking their sex into consideration. These were arguments that we had pushed ferociously against and said, no, whether we think it's good policy or not, which obviously we don't think that's good policy to have sexual orientation, gender identity in the law, that's the job of Congress to do. That's not the job of courts. And as it stands right now, the Rost and all of these other employers had never been told that they can't have a male-female dress code policy, or that they can't make employment decisions based on these factors. But Justice Gorsuch and the majority sort of threw all of those out and said, if you look at it as a textualist originalist, which Jim may talk a little bit more about how the dissents approach this, he said, because sex is a factor and you would treat two employees differently, if they were both married to a female based on their sex, then that's somehow violating Title VII. Again, we disagree with that. We don't think that's an accurate scenario, because you're not only changing their sex, you're also changing their sexual orientation. And that was ultimately a lot of what was involved here and what the case was about. So it was a disappointing thing to see from Gorsuch for a couple reasons. Number one, we don't think this was in line with what the sort of the textualist originalist approach should be. It ought to be very much of what did the drafters of Title VII intend when they did this. And they never would have envisioned this encompassing a male wanting to dress as a female. I think secondly is he sort of swiped all of the concerns that were brought up in this case, of what this is going to do when you are redefining what sex discrimination is in all federal law, in state laws that ban it as well. And he sort of brushed it aside and said, well, look, we recognize there's religious liberty concerns and issues with locker rooms and restrooms, but that case is not before us. Those are for another day. And so it was troubling to see that majority opinion just sort of bypass all of those concerns, ignore all of those, and ultimately do what it was legislating from the bench.
Let me reiterate, first of all, that Mr. Gorsuch was the first pick of the court by Mr. Trump. And Mr. Trump was specifically looking for someone who was going to view the law similar to the great late Justice Scalia. And that was supposed to be Mr. Gorsuch. And you look at his past history, he was right on the money with respect to the Religious Freedom Restoration Act in the case that ADF also took to the Supreme Court. And he was and always has been a very solid guy in the brief time he's been on the court. And the issue, as Matt said, was what is the meaning of sex? What did it mean? And more specifically, what did it mean back in 1964 when the Civil Rights Act was enacted? Now, one thing that the court mentioned, and this is a key, there wasn't a whole lot of legislative history with respect to what sex meant. The Civil Rights Acts back in the 1950s and 1960s was very, very contested. All the Southern Democrats were lined up against it, trying their best to stall it, to try and defeat it, and it looked like it was going to pass in 1964, and therefore a gentleman by the name of Mr. Smith, Representative Smith, Congressman Smith, did an amendment to include with race sex. And it was kind of a poison pill. In other words, let's see if we can stall this or defeat this by bringing in a whole new category of cases that would be covered by this. And without a whole lot of discussion on the subject, the majority of Congress at the time said, yeah, all right, let's include that also. So let's not only have race, let's also have sex, and let's also have handicap, color, nationality. I think those were the original ones. Of course, the act has been defended to include, or has been amended to include things like age and handicap and things such as that. Anyway, Mr. Gorsuch starts the opinion by saying the following: this court normally interprets a statute in accord with the ordinary public meaning of its terms at the time of its enactment. Right? That's great. Our side always agrees with that. That's what the originalist approach is all about. You look at what did the words in the statute mean to those people who were enacting it at the time of its enactment. A little bit like the Bible, isn't it? I mean, these words really mean something because it tells us about who the drafters were. And although obviously the drafter was God with respect to the Bible, but you have to pay attention to words, and it's important that you give respect to the people who are actually drafting these words. But what did it mean to them? And much of the dissent, particularly by Justice Alito, Justice Alito did just rip to shreds Gorsuch in his opinion. He went on and on and on, and showed that back in 1964, no one was thinking that sex included sexual orientation and gender identity. Matter of fact, he went through all the different examples and said, look, every state but Illinois, my home state, had laws that actually outlawed, right, sodomy, the sexual act with respect to homosexuality. Those were all outlawed. How could those be included in the drafters, by the drafters, when they're looking at the word sex? He said it didn't happen. They did not think of that. No one even knew what gender identity was. Matter of fact, you take a look at homosexual, he went through the whole history of the American Psychological Association and how they viewed that for many years throughout this entire time, viewed homosexuality as a sexual deviation worthy of treatment. And of course, if you're committing sodomy in one of the states that outlawed it, you're a criminal. So how could you be protecting those individuals in that society, in that culture, when you're talking about sex? He said it's ridiculous to think that this was meant by these legislators back in 1964. And he went through the history of the federal government, teachers at that point in time. He talked about teachers in California who would lose their jobs if they were gay. And you're saying these were the people that were protected by these individuals back in 1964 when they were drafting this particular provision? And he also mentioned, and so did Justice Kavanaugh, who also dissented. He also focused really upon what the ordinary public meeting at the time of its enactment was all about. And again, he ripped into Justice Gorsuch in his opinion along the same lines. But both of them said, what you have done here is legislate. Congress over the past dozen years has tried again and again and again to amend the statute to include sexual orientation and gender identity. Certainly they didn't think that was included within the term sex when thought of when enacted initially in 1964. No, they meant gender, treating men and women the same with respect to employment decisions. That was the limit. It may have been changed a little bit since then, but certainly not this. And that's why everybody's been looking for it. And the same thing happened here in Virginia last session. If sex always included gender identity and as well as homosexuality, why did they bother amending the statute here in Virginia recently? Why bother? So those were the primary.
Excellent. Helping us work through sort of the general rationale for the majority, and then of course the dissenting thought process, which I think we relate to a lot better and understand a lot better. Okay, I think people are wondering, so who actually is affected by this ruling? So you've got the people in the cases. So who is affected directly? And maybe Matt, you could answer that a little bit. And then maybe if Jim, you would be open to, oh, I'm sorry, Jim, maybe you answer who's affected directly, and Matt, maybe you open the question, what does it mean indirectly? Who's going to be affected indirectly?
The Justice Gorsuch, in his opinion, really focused upon the fact that, look, what you're talking about in this decision is Title VII. What this is all about is employment discrimination, and that's the only law that's changed here. And he limited it in so many different ways. But he said that Title VII deals with employment discrimination, and now, in addition to, you can't discriminate against people over 40, you can't discriminate against racial minorities, you can't discriminate in employment decision regarding handicap, you can't discriminate on the basis of nationality and color, and now you can't discriminate with respect to gender identity, nor can you discriminate with respect to being homosexual. And so therefore, Mr. Zarda, who's no longer living, he would not have been fired. Mr. Bostock, who still is living, would not have been fired, and he's going to get compensated in some way for this. And Mr./Ms. Stevens is also going to be compensated, although she is also not living, from what I understand from the opinion. But that's the direct effect. The direct effect is employment decisions. You can't make them with respect to gender identity or sexual orientation anymore.
Yeah, and to build on that, the frightening part of this decision is the analysis Justice Gorsuch used, which was breaking apart what is sex discrimination, could potentially apply in every law that governs sex discrimination. That includes laws like Title IX, and so that's at the educational level. That's laws dealing with public accommodation. So many states do not have sexual orientation or gender identity, just like the federal government doesn't, and Virginia didn't last year. But do have bans on sex discrimination. So the indirect concern is if you take Justice Gorsuch's reasoning and you apply it to every other law banning sex discrimination, you end up with now those same terms being added to all of these other state and federal laws.
Okay, let me get even more specific. Can you talk about, and maybe Jim, you tackle this one at least to start, some of the major implications of this decision for religious liberty, and especially we're talking about are churches affected, religious schools, faith-based nonprofits, and maybe as a constitutional lawyer, maybe you could speak to how about the kind of the rule of law in a constitutional system. What else is impacted here?
In many ways, the decision here will have more limited impact upon religious institutions than it does upon the general employers, right? Non-religious employers, because there are certain protections for religious employers that others do not. Let me give you an example. There is a ministerial exception, it's called, which is also going to have another important case come down shortly. Our Lady of Guadalupe deals with Christian schools. And in the ministerial exception, the government basically says, we're going to stay out of the decision about a church employing a minister. That's a matter of faith, a matter of doctrine. It's something that we shouldn't be going into because of church-state separation, and therefore we are not going to make a decision whether a church fires or in any way disciplines one of its ministers. With respect to teachers, that's a different issue. And that's what Our Lady of Guadalupe is going to be all about. How far does this ministerial exception go? Certainly, you might include a principal in there. You might include a Bible teacher. But what about a math teacher? What about a social science teacher? Are they also covered by this ministerial exception? What if they have no impact with respect to the chapels that are being held in the school? What if they don't have a prayer that they lead or Bible studies that they lead? Are they also within this ministerial exception? And of course, we say, of course. Matter of fact, an argument could be made that a janitor for a Christian school should be part of that ministerial exception, because oftentimes a janitor is one of the most important people there in terms of showing Christian love and Christian compassion and modeling. And that's an important thing when it comes to Christian school employees. What they model for the students has as much of an impact upon as what they say. And so that is an issue with respect to Christian schools, also with respect to other religious nonprofits. And so you have the ministerial exception. You have the Religious Freedom Restoration Act, which protects the religious liberties of religious organizations as well as religious individuals. In addition to that, you also have certain protections under Title VII. Title VII allows a religious organization to hire people of its own faith. Now, that can even be a little problematical. I recall during my PhD dissertation writing about a teacher, a person that was applying for a job at Marquette University over Milwaukee. And this particular individual had gotten her PhD from Georgetown University, the Catholic institution. She claimed to be Catholic, same faith. But she applied for this position. She did not get it. She sued. And the Marquette University said, right, she's of the same faith, but she doesn't believe in our issues. She was a pro-gay advocate. No, strike that, a pro-abortion advocate, right? Something specifically against the Catholic doctrine, but yet looking for a job. So it becomes an issue. Well, what does it mean to be of the same faith? And in that particular case, the court got it right. It said a person who is nominally Catholic but doesn't believe in Catholic issues is really not a Catholic. And therefore, the court said, you are not protected here. And so you're going to see all of these issues come up because Justice Gorsuch was right on the money when he said, look, all those issues that Justice Alito had included in his dissent, like what's going to happen with religious organization, what's going to happen with women in sports, what about this, what about that? He said all of those issues are not on the table. We don't have any of these issues before us. We'll talk about all of them in litigation in the future. And we're only dealing with gay and gender identity people in employment actions in this decision.
I think, you know, we were very glad to see the comment in the majority opinion where they said the RFRA issue, this Religious Freedom Act, Restoration Act, you know, does have some superseding qualities, and you know, they sort of left that door open. And so obviously we're hoping to see that they interpret the ministerial exception very widely, that RFRA has really controlling power. And as you say, that will all play out as these cases continue to go forward in other realms. In Virginia, just so everyone's aware, when we dealt with the Virginia Values Act, the amendment we were working on really hinged on this issue of, are we talking about labels? Like, I'm a Christian school, this person says they're a Christian, or are we talking about tenets of the faith? And that's what Jim was just getting at. And that really becomes critical because, as we know, everybody can wear a label. It's what you actually believe, and you act according to your actual beliefs in your heart. So that's important. All right, so let me shift this over to Matt a little bit. So no impact on bathrooms, sports, locker rooms, you know, or you know, they say that wasn't before them. What does that mean?
Yeah, I think this goes to that concern I was raising. The majority may say that's for another day, but if the same reasoning applies, then why is a sex-specific bathroom? If you tell a guy and a girl that both want to go into the girl's bathroom, girl, you can go, but guy, you can't, that same reasoning from Justice Gorsuch would seem to apply. So the concern is when everything is now a type of sex discrimination, that if you don't allow the guy that thinks he's a girl into the girl's locker room, or to sleep in the girl's dormitory at college, or to play on the girls' sports team, and we see the consequences of that. So ADF has a case going on in Connecticut right now on 3 high school athletes, 3 great female track stars, that within a 2-month period, a guy that had been a mediocre runner asserts a female identity and starts competing on the female track team. And next thing you know, 16 championships he's taken, numerous state records that have fallen. I think over 80 or 90 different opportunities where a girl lost out on a spot on the podium or advancing to the next round of competition because 2 biological males began taking over and conquering track and field in Connecticut. And under this decision, this could potentially be rolled out to other states and across the country. You even think it's something like the WNBA. They are employees. The female basketball players are employees. So does this mean now that LeBron James can come and dominate the WNBA as well? We also see issues with women's shelters. Does a biological male now get to go into a women's shelter because he claims to be a female? And what does that mean for the women fleeing sex trafficking or abusive situations that deserve privacy and safety in those facilities? So I think that's a lot of these consequences that we may see lower courts take this decision and use to force those consequences across the country.
So not before us today, but logic going to be a real problem when it actually gets before the court. Let me just, for people who haven't read the opinion, let me just clarify. There is nothing in this opinion that says, and I have to be kind of specific, there's nothing in this opinion that says in order to be something, you know, female or male, it's about body parts or hormones. It is just about how you feel. Is that accurate?
Yep.
Okay. All right. Wow. All right. Well, let me ask this. A case near and dear to our heart here in Virginia, Peter Vlamming, a teacher who was impacted by simply saying, as a matter of who I am and my faith, I can't lie about somebody's gender by using the wrong pronouns. He was extremely respectful and absolutely was willing to call this person by their new name, since names are sort of a neutral thing. Okay, I got to think that this ruling might have some impact on that case. How does it look for our friend Peter here in Virginia?
Yeah, same sort of concerns. And this is in the employment context. So that they can't say, well, that, that's another situation. This is employment. So if I'm not, calling someone by their preferred pronoun, or not acknowledging that the man who wants to be a woman is a woman now, am I creating a hostile environment based on sex? Am I discriminating based on sex because I'll call the woman Mrs., but I won't call the man Mrs.? And again, you take Justice Gorsuch's reasoning. If both people want to be called Mrs., but I refuse to do so for the man and do so for the woman, that's sex discrimination under this reasoning. So it is troubling for Mr. Blaming, and we've got other cases, a college professor in Ohio, Nicholas Merriweather, and several other dealing with this pronoun usage. So now it's not just, are you hiring or firing someone? It is telling employees and employers, you have to use inaccurate, what we believe, false language to speak something that is not true, to call a man a woman. You must do so, or otherwise that is sex discrimination based on sexual orientation or your gender identity.
And Peter Blaming's case is going through state court. It will head to the Virginia Supreme Court, if I'm correct, but doesn't matter. This is going to have, a big shadow over everything. Yes. Okay.
That's right.
Jim, let me just ask you to reiterate one more time, because this is of just deep concern to so many of our folks. Just reiterate one more time what we think we have in religious freedom protections. So a lot of our folks are part of churches, Christian schools. Just kind of outline for them the couple of things, anything that's in this opinion that's hopeful, anything in Title VII that's hopeful. Just kind of give us a real quick rundown on that.
Let me just repeat some of the things I said before.
Yeah.
With respect to churches, with respect to schools, the ministerial exception. Again, the leaders of an organization, a religious nonprofit, should be covered by that. The question is, how much does that extend down to other employees? Certainly would a chaplain, certainly would be perhaps a Bible teacher. But how far does that extend? And we'll have more guidance from the ministerial exception from the court later on this term. So within the next week or week and a half. Secondly, Religious Freedom Restoration Act is a very important tool that Matt will explain briefly. That was a claim that ADF made with respect to the Harris case, so he'll comment upon that a little bit. But that's another very important tool to use. And then again, the protections with respect to Title VII given again to religious nonprofits. It gets to choose people of the same faith, and we talked a little bit about what that means. And it also deals and protects religious employers who are hiring people for activities within the organization. That's another thing that was talked about in Title VII. So again, some very important protections also. Those are all with respect to religious organizations. With respect to the Title VII itself, normally it does not affect small business. In other words, there's a statutory limit, statutory protection with respect to small business under the Federal Act. But Virginia and many other states are now covering that for employers who have less than 20 employees, and therefore not subject to the Federal Act, but they're now subject to state laws. And again, because the language is all similar, sex now includes gender identity as well as homosexuality.
And just a real quick question, sort of back to Matt. Tell us again why the court didn't consider any of these things, why this didn't seem to matter for these businesses.
Yeah, so part of it was, Harris Funeral Home was not sort of asserting its right to only hire people of the same faith. Rather, what it had originally done was to assert RFRA. This is the Religious Freedom Restoration Act that says that the federal government can't burden your religion unless it's got a compelling reason for doing so. And whatever burden it's imposing is the most narrow one necessary to accomplish its goal. This was the law that allowed Hobby Lobby to prevail so that it didn't have to pay for abortion-inducing drugs in violation of its faith. So with the RFRA, unfortunately, the Sixth Circuit Court of Appeal had rejected the RFRA defense and essentially said it does not serve as a shield to these anti-discrimination laws. So as the decision, in deciding what to take to the Supreme Court, a lot of the thought was, look, we don't want just protection for a devout religious family from these laws. We don't want it to just be that, well, the faith-based family can limit themselves and only hire people, without regard to sexual or with regard to sexual orientation, gender identity. We wanted to make sure that Title VII was applied like it originally meant to. And so a lot of the thought was, let's focus on that originalist. We were looking at the judges as we thought with Gorsuch and Roberts and Alito and all of these and say, these are originalists. They're going to uphold that original meaning. And I think that was a lot of the strategy. And that's why the sting of the opinion hurts a little more, because that prediction that so many had that these are originalists, they're going to stick to what the Congress meant in 1964, unfortunately did not prove true.
Yeah, we talk about the impact of this case. I guess in one sense, if they were going to rule wrong, I'm glad it didn't involve our freedom of our faith. I'd rather, hopefully test that in a great fact set and all that. But I found myself, when a reporter asked about the impact of this case, I found myself reflecting back to when Lawrence v. Texas, and I'm aging myself right here, but when Lawrence v. Texas passed and it was, okay, sodomy is now legal, and they said, oh, it won't go to same-sex marriage, it's just between two people in their bedroom. Then we get Obergefell, and these were kind of earth-shattering cases, and here we are today. Okay, so how serious is this really for future cases? And am I wrong to feel like this is pretty big?
Yeah. No.
Matt, you want to start us?
Yeah, this is going to be a setback. You mentioned, the previous cases from Obergefell and others, and you read the dissents in those cases and the warnings that they give, and one after the other has come to fruition. And so when you read Alito's dissent here and saying all of these things from women's sports and restrooms and locker rooms and pronouns to even some of our constitutional norms are all at risk. I think we ought to perk up and take notice of that, because every one of these predictions that justices in the dissent have made have come to fruition. And so I think there's going to be a massive amount of litigation, and we can be certain that the other side is immediately going to capitalize this, start filing cases against religious nonprofits and say, you fired that person, or you didn't hire that person because they lived a homosexual lifestyle, or because they wanted to dress as a woman even though they were a man. And we're going to have, I think, a lot of litigation come out of this. Hopefully we'll get some balancing, but I think it's going to be a long battle.
This is a bad decision, specifically with respect to the rule of law. That's something that's near and dear to my heart, and near and dear to the heart of many of Family Foundation supporters, because the rule of law basically holds us together. And please remember this, that we are protected not only in America by the Bill of Rights, but we're also protected by the unamended Constitution in terms of the structure of the government. Now, remember what the framers did here. The framers recognized that man is evil by nature, right? Is sinful by nature. Man is interested in pursuing greater power for himself, for seeking greater wealth for himself, and therefore there's got to be a structure in place whereby you have checks and balances. And under checks and balances, you have a Congress that makes the law, you have a president that enforces the law, and you have the judiciary that interprets the law. Well, interpreting the law is a lot different than making the law. And here, as noted by not only Justice Alito, but also Justice Kavanaugh, you had them making law. For years, they've been the other side's been trying to amend the statute to include sexual orientation, to include gender identity, because it wasn't covered in 1964. Now the Supreme Court, with 6 unelected justices, have made that decision and have removed that from Congress. Who knows if Congress had actually dealt with this and had actually moved on this? I mean, there have been bills and bills and bills in every Congress for the last 20 years to change this law. What type of protections could employers have gotten if they continue to resist? In other words, at some point in time, is the other side going to throw the employers a little further exemption? What about for religious organizations? Should the religious exemptions now in Title VII be buttressed? No, that's all off the table by 6 individuals. Now, another interesting aspect of this case is that both Justice Gorsuch as well as the Chief Justice, they sided with the liberals. Now, interestingly enough, none of the liberals wrote an opinion. There's no concurring opinion here, which is very unusual. So you had 2 originalists. You had Alito looking at what does ordinary public meeting of the terms at the time of the enactment, and that's what he focused on. You had Gorsuch giving lip service to it, but then looking only at the text. I mean, his opinion, when you look at it, he didn't really go back and examine what life was like in 1964. He focused upon what does discrimination mean? What does sex mean? What does because of sex? Words, textual words, rather than looking at public ordinary meeting. And so that's in my opinion, that's why it's flawed. He did not look. He lost the ball. You know, he was so busy looking at the trees, he lost looking at the forest. And the whole concept, again, he got it right at the beginning. This is what we're going to be looking at, but then he lost it. He moved away from that and only looked at their words. And I'm surprised that John Roberts agreed with him. I don't know what's going on with that guy.
Yeah, I found myself reading the majority opinion, almost wishing it was a court full of liberals, because I almost found it more heartbreaking to read somebody say, we can't legislate from the bench, and then seeing them legislate from the bench, and our hearts should stop and think, if this is his idea of not legislating from the bench, we're in a world of hurt on a number of other cases. So I think it had everybody kind of gripping, going, what else is down the pike? Obviously, we had another decision today. We'll have a bunch more in just the next 2 weeks. We'll really get a feel for this justice. But let me go ahead and just last question that we had sort of pre-prepared, and I'm going to mix it with a question that's one of our folks on the call has put in there. I guess we'll start with you, Jim. The question is, what can people of faith who maintain orthodox views on marriage, what can we do to protect ourselves against these claims, against litigation, and specifically, if you would answer this question with regards to faith-based entities, I think is one kind of answer. And then our supporter over here on the call kind of said, if you're a Christian business person, are you able to ever, in any context, consider sexual orientation, gender identity in your decisions, because they violate your convictions on how you operate your business? So maybe look at it 2 ways: private, faith-based, and then how do business people protect themselves, or is there anything they can do?
Certainly, and I back in my former life back in Chicago, did a lot of employment litigation. So represented a lot of employers on a variety of issues. Not on this one, obviously, but a lot of others. The best thing to do as a private employer is keep good records and have very good rules of conduct, because we're talking about breaking rules of conduct. And Justice Gorsuch said, look, this is not a case where one person was habitually late, one person was unproductive. Those are things that certainly go beyond gender. I mean, a man can be unproductive, a man can be late for work, sloppy with his work. So can a woman, and those are are things that employment decisions can appropriately be made. But you should have the code of conduct certainly present and available. Everybody should understand it, and then enforce it. With respect to religious organizations, we kind of looked at this back when Obergefell came out. I've been a former president of the Christian Legal Society, and we did some draft bylaws for religious organizations. I know that Alliance Defending Freedom also did some. And so those are available, I think, on the Christian Legal Society website. My guess is that they're also available on the ADF website. And just a month ago, the Family Foundation completely restructured its bylaws to say we are a religious organization. These are the issues that we get involved in. We want everyone to sign off on our issues. These are what we stand for. And therefore, if you find somebody that's against those purposes, that doesn't adopt our statement of faith, that's a reason for not giving them employment. So be very, very overt that you are a religious organization, and that means a big deal to us. And if that involves restructuring bylaws and articles of incorporation to ensure you have that defense, take the opportunity now to do it.
Yeah. And I'll just add really briefly on the, what about the secular employers? You're not a religious business in the, it's like a Christian bookstore or something like that. Again, I'm going to hold Justice Gorsuch to his word. This is not about bathrooms and restrooms and all of that. So I think there is a duty to still, even if you're just a regular employer, keep separate sex-specific restrooms, changing rooms, things like that. That is your duty to the privacy of your employees. Second is we still have other cases and litigation on a lot of these issues, including as it relates to speech. Remember, Jack Phillips, the Colorado baker, was a private secular business owner, and part of the thing was, can I be punished for my speech, for what I create that has an expressive component to it? So there's going to be cases where we're defending secular business owners' right to have religious speech and to not be punished for that and all of this as well. So just some hope Jim's advice is right on. I mean, just to think of your religious mission and your documents to keep good records, but also remember there's still a lot of protections that we are going to continue to fight over on this area.
Excellent. We've got a good sort of philosophical question from one of our folks. In addition to legislating from the bench, has not SCOTUS in this moment essentially de facto created a new religious sect, right? So we always see this clash between religious freedom and sexual orientation, gender identity. And for those of us that, that are watching this, we feel like it's become a religion. It's become, so, by saying, this is gonna be the law of the land. Have they sort of created a religious sect according to their whim and sort of imposed it on our society? Anybody have opinions on that? Thoughts?
That is our official religion, secular humanism. The Supreme Court recognized it in a footnote a long time ago that is a religion. But every time that our side argues it, they said, no, we're simply being irreligious. We're not in favor of anybody. That's why we keep all the stuff out of government and public schools and things like that. That's all a lie. I mean, literally, you take a look at their worldview, and their worldview is secular humanism, and that's one of the reasons why I spent 54 years of Christian school tuition for my kids.
You've added it up. I don't want to add it up.
And it was worth every penny.
Yeah, that's encouraging. Matt, anything you want to add to that, or you feel like he's got that?
Yeah, I guess the one thing I'd add is a lot of the courts, as we saw in the Harris case, when there's a conflict between religion and these secular values and sexual orientation, gender identity, religion loses. So in some ways, it's not even like another sect. It's sort of like you've got now a super set of beliefs and ideas that even trump religion. The very first thing protected in our Constitution, the freedom of religion, and there's now things that can easily trump that.
We typically tell our students when we have an Equip Academy where we do worldview with college students, and my opening talk is about all laws are someone's morality, right? All laws come from someone's worldview. And unfortunately, more and more of them are coming from secular humanism, as Jim has pointed out. And it's like this super seeding over top of everything, trumping our ability to have our faith. So good question. Another question I think everybody thinks about, what's the recourse when a jurist with a lifetime appointment, clearly legislated from the bench, even a judge with an originalist history, abandons the rule of law, and what are we supposed to do?
Yeah, I'll say one thing I've been reminding people is years ago, our dear Justice Scalia issued a really bad decision in a case called Employment Division v. Smith. This was actually the case that led to RFRA, because Justice Scalia said, anytime if there is a law, as long as it applies neutrally to everybody, it can trump religion. And in response, there was a strong bipartisan backlash, and we ended up with the enactment of RFRA to say, SCOTUS, you got it wrong. We are going to put religion in its proper place. Now, look, I'm not a Pollyanna that thinks there's that same sort of motivation right now, but this is going to cause a backlash. And I think there are legislative ways, both at the federal level and even at the state level, to cabin in this decision, and maybe to restore some boundaries to what it impacts.
Love your optimism, Matt, but I go back a few more years, back to the 1960s when the Supreme Court ruled that prayer is no longer proper in the public schools, and there was a public uproar at that point in time, and there was a constitutional amendment that was provided, and then in 1973 with the Roe versus Wade decision, another huge backlash. Another outroar, and matter of fact, I was circulating petitions. The first petitions I ever circulated was to the Supreme Court or the government to do something with respect to Roe versus Wade. That type of backlash was going around. And again, the constitutional amendment to try and overturn that decision, both fell short. Okay, how much legislation do you think is going to be passed now when you have the Democrats who enacted a bill that had a gender identity and sexual orientation already amending Title VII? I mean, that passed the House. Matter of fact, that particular bill was so bad that specifically cut down on religious freedom. Luckily, the Senate didn't take it up and won't take it up, and maybe all of that will go at this point in time. But I don't look to Congress and in this climate to do anything to straighten out this decision, and I don't see a constitutional amendment to do this. I think this is something we just have to sit through, and at some point in time, the court it'll dawn on the court that yes, you're right. Roe versus Wade was wrong. We should return this issue to the states, and we were wrong here too, and therefore we'll do it. Just like hopefully in Employment Division versus Smith. I mean, that's being challenged right now in the Fulton, Philadelphia case, the foster home case, and whether we should even have the Smith case live on. That's the way I think we're going to do it. Only by the Supreme Court saying, "Oh, we made a mistake." It's time to overturn that.
I often, when I'm with a reporter talking about this issue, I often say the reason, in addition to it was not set up to do it this way, the reason we don't want the court legislating from the bench is they are ill-equipped to handle the nuances of these broad decisions in every facet of life. And that's the challenge we have here is Congress can, the process is designed to think about these one-off scenarios and does it apply to this environment? And then you have interest groups. There's a reason the system was built this way, and the court simply cannot effectively address that. And so we're devastated to see this decision. And we know it has broad impact in Virginia. Obviously, we were already gearing up for the Virginia Values Act, which goes into effect July 1. And I'm going to just sort of kind of wrap our time here by reminding people that law essentially does a lot of this stuff. It is the non-discrimination. It is in the workplace. It does not do a great job carving out schools, churches, people of faith within the legislation. We begged and pleaded and arm wrestled, and ADF came with us, and we we did everything we could. And bottom line, they were pretty honest that their intention is to force a Christian school to hire against their faith. That is the world they want to live in. And that is what they're trying to do here in Virginia. So we were already here, and we are we just have been aware this was coming. And so at the Family Foundation, we have kind of buckled down and said, okay, public policy is one route, the legislature is one route. We are going to have to kind of step up and help Alliance Defending Freedom in a different facet and actually enter the legal system. Because if you think about it, ADF has to handle this around the country in 50 states, and actually internationally. A lot of people don't know about all their international stuff, but here in Virginia, we want to stand behind churches and schools and people who are going to continue to walk out their faith, and we ask you to do that. We don't. The suggestion is not, okay, the law has spoken, we all bow down to it. We know what the higher law is, and so our job is to stand with you along with ADF. We're excited to have the Founding Freedoms Law Center. We haven't publicly announced it, but it's already at work. We've already won our first case on the pro-life front. We were defending a client outside an abortion center during COVID, and they decided that for some reason you can have an abortion center, but you can't have an ultrasound unit outside. So we've already gotten that criminal citation dismissed. We're back in court actually arguing that the state can't hide from a taxpayer the reasons why we pay for abortion. So we're actually, next week, we'll be in court saying, no, Freedom of Information Act, we get to know what our tax dollars do. And so there's a lot of facets of legal work that we're going to be doing. And so if you're not aware of that, we're here to help. If you think your church or your school or your pro-life effort needs defense, feel free to check in with us at the Founding Freedom Law Center, along with ADF and the awesome work that they do. We promise to try to keep this to an hour. We have hit the questions that came in on the side, I believe, hopefully. I think we've caught them all. So we could talk a long time about this. It has far-reaching tentacles, unfortunately. And we know there's more to come from the court in the next couple of weeks. So I suspect we might find ourselves back on a webinar talking about some other decisions. A big school choice decision, something that's very important for school choice, is coming down, a number of other things. So with that, I'm going to go ahead and wrap this up for the evening and say that we're thrilled to have had Matt Sharp from ADF and Jim Davids, part of the Founding Freedoms Law Center that we're starting. And we're just thrilled that you all joined us tonight. So on behalf of the Family Foundation, I hope you found this helpful. And if you have further questions, feel free to reach out through our website or through my email, and we'll check in with you individually. Thanks so much for being here tonight. And thank you, gentlemen, for helping us walk through this.